I've got Greg Archibald and Micah Saul. Let's turn to them for McNees. And they're specializing in advising our employers on workplace policies, discrimination claims, labor matters, bringing unique insights to clients and their legal challenges. Today, they'll dive into the important topic of employment law, exploring recent developments in diversity, equity, and inclusion and discrimination law, workforce impacts of the evolving immigration policy, and the latest updates from the National Labor Relations Board, along with some notable state-level deviations from the federal employment policy. Micah and Greg, take it away.
Right. Good morning, everyone, and thanks, Nikel, for that introduction. It's great to be back. A lot has happened since the last time we were with all of you around this time last year. And so we want to take a look back over the developments in labor and employment law that occurred in 2025. And we also want to take a little bit of a sneak preview as to things that might be ahead for us next year before we get together again around this time next year. So with that, first thing we want to talk about, and Jennifer talked to all of you about this earlier this morning, the One Big Beautiful Bill provision with respect to no tax on tips and overtime. So as employers, I think many of my clients heard that provision being passed and they thought, what does this mean? Are we going to now have to exempt overtime pay from tax? How are we going to fight with this, wrestle with this? How are we going to get ourselves into compliance with not taxing overtime or tipped wages in such short notice? The good news for employers is that we really don't have to change the way that we're paying employees. As Jennifer said earlier, we're not required to, or not just not required to, we should not be exempting overtime or tipped wages from tax. We're still making the applicable payroll tax deductions from those wages. The way that the One Big Beautiful Bill has quote unquote exempted those wages from overtime is to make overtime and tips eligible for a tax deduction when employees file their tax returns at the beginning of next year. And so with respect to overtime, very important thing to note for employees so that they're not surprised, only the overtime premium amount is eligible for the deduction. So when we talk about overtime, we typically think of the old time and a half format. It's only that and a half, the overtime premium, that goes toward the deduction. The deductions are limited to $12,500 for single filers and up to $25,000 for joint filers. And so again, with respect to overtime and tipped wages, employees will be able to claim deductions for those wages. So one of the questions that had remained until relatively recently was, how are we supposed to track that? Because most employers on employee W-2s are just noting their gross pay, not segregating wages, not segregating tips necessarily on W-2 forms. What are we supposed to do with respect to that? And we have talked about this now since the One Big Beautiful Bill was in process earlier in the year and then ultimately passed in July. And we were unfortunately forced to give the answer of, we're not really quite sure. We're waiting for the IRS to kind of give us a little bit of direction here. There were some rumors about maybe the Form W-2 would be revised and amended for 2025 at some point. That ultimately did not happen. So you will not see a new Form W-2 for the tax year 2025. It will look the same as it has in the past. So what the IRS has done is it's offered some guidance and some suggestions for employers to allow employees to ascertain how much money they've earned through taxes and tips so that they can claim their deduction. And there's a couple of ways that we can do that. So first, with respect to tips, in W-2 Box 7, there's a indicator for Social Security tips. Employees who receive tips can use that Box 7 reporting to determine the amount of tips that are potentially eligible for their deduction. With respect to overtime wages, there are a couple of ways employers can report that to employees. And that is potentially through an online portal. If you have, like, for example, an ADP platform, your payroll platform, where employees can go and access their pay records, you can report to them their overtime wages through that online portal. You can provide employees with a separate written statement of their overtime wages, or if you're feeling especially proactive on this, you also have the option of reporting overtime wages in Box 14 of the current W-2 form, which is designated as, quote, other. You can report overtime wages in that form. So it sounded like a really big kind of shift in the way things were to be done with overtime and tips, as it relates to taxation, when we hear no tax on tips and overtime. But in reality, this is now a deduction that employees can claim, when they file their taxes. It's just a matter of us, as employers, sort of providing them with that information so that they can claim their deduction. One Big Beautiful Bill also had a couple of impacts on employee benefits as well. There were a couple of expansions for certain employee benefits that many employers offer. As you all are, I'm sure, painfully aware, with rising costs of health insurance, high deductible health plans with corresponding health savings accounts are becoming a more and more attractive insurance option for a lot of employees. And the One Big Beautiful Bill Act expanded the expenses and costs that are eligible to be paid with HSA funds. So telehealth coverage before employees meet their deductibles can now be paid directly out of an employee's HSA account. HSA funds can also be used now to pay for direct primary care. And for those that might not be aware, direct primary care is a healthcare structure where employees or patients, I guess, in general, can pay a direct fee to a doctor without necessarily running through insurance. There are essentially doctors out there that provide, it's almost like a monthly subscription kind of fee, where you can come in and you can do your well visits, you can do your sick visits, things like that, for a monthly fee. And now employees can use their HSA funds to pay for that direct primary care that's not run ultimately through the employee's health insurance. Before the One Big Beautiful Bill Act, employees weren't able to use their HSA funds for that benefit. Now they can. And so we think the net effect of this change is that, we're going to continue to see employees participating in HSA and high deductible group health plans. So just some added benefits for employees to be aware of, who subscribe to those plans. There was also an increase under the One Big Beautiful Bill Act to dependent care flexible spending accounts contribution limits. This is not mandatory. Previously, the limit on a flexible spending account was $5,000. Employers are now allowed to expand that flexible spending account limit to $7,500. And that will be effective January of 2026, you're allowed to make that change. If you do make that change, there's a couple of things for employers to note. Number one, you need to amend your cafeteria plan documents to reflect the new limit of anywhere from $5,000 to $7,500 if you do increase it. So you want to make sure that your plan documents are consistent with your limits. And then also you want to make sure that you run any increase through non-discrimination testing under the tax code. So the IRS has implemented on certain employee benefits non-discrimination testing, which essentially seeks to ensure that individuals who are highly compensated aren't eligible for better benefits than individuals who are not highly compensated. And one of the rubs with the FSA is that with the limit of $5,000, the existing limit of $5,000, a lot of plans come really close to that non-discrimination testing limit. So if we increase that FSA limit to $7,500, it is possible that you could potentially step over that line of the non-discrimination rules under the IRS code. And so very important to do that non-discrimination testing if in fact you decide to increase your FSA limits as permitted by the One Big Beautiful Bill Act. So another impact of One Big Beautiful Bill is that the Immigration Customs Enforcement budget has nearly tripled. And you might think, Micah, why does that matter for employers? What does that have to do with the workplace? I think probably most of the folks who are with us today have seen news stories or at least heard others talking about the concept of ICE raids. Immigration's Customs Enforcement raiding workplaces, job sites, looking for folks who may be in the country unlawfully or without authorization. And so the ICE budget increase nearly tripling. We've heard that there's an intent to hire approximately 10,000 new ICE agents. And so we expect that enforcement activity to increase as a result. So it is entirely possible that we will see over the next couple of years increased ICE activity in various workplaces. So what workplaces are most at risk? Right now, we tend to see ICE raids occurring most frequently based on two factors. One is geography. So if you operate a business in a place where there are traditionally high levels of immigrant populations, it's more likely that ICE will focus their initial enforcement efforts in those areas, geographic areas. And the other is also the type of industry that you're in. So if you're in an industry that typically employs a lot of immigrant labor, construction industries, blue-collar industries, tech industries, those are the industries that we think ICE is going to focus on initially. Now, of course, as we move through the years and we see this kind of unfold, we may see those enforcement efforts expand beyond, the geographic ties or the demographic ties to specific industries. And we think it's a good idea for employers, especially now in those geographic red zones and the demographic red zones, to start thinking about, what would we do? How would we handle it if ICE shows up at our workplace? And this is an important thing to think about now, because it's much better to have a plan and not need it than to need a plan and not have it. And you get surprised by, ICE knocking on your door, wanting to come into your workplace. And now what do? We don't want to be, kind of shooting from the hip with ICE on property because there are some risks, right? So if ICE shows up and we impede or interfere with their investigation, depending on the conduct that's taking place, there's potential criminal ramifications for anyone that would be aiding or abetting what ICE would perceive to be a violation of immigration laws. So That doesn't mean we have to, completely open the door and there's nothing we can do. There's no option for us to make sure that we're subject of a lawful ICE raid. But we do need to have a plan in place. We do need to be thinking about what steps would we take if ICE does in fact enter our workforce. So a couple of things that we're recommending for clients. Number one, this is a topic of conversation that we strongly recommend that you have with legal counsel, because there are, again, civil penalties at issue. There's potential criminal penalties at issue. There's obviously workplace security concerns, morale concerns with your workforce. In the event that they would feel an ICE raid is likely, or if an ICE raid does happen. So it's a good idea to talk with legal counsel about what your plan should look like. Generally, there are a few steps that we do recommend for all employers. Number one, you do have the right to ask if ICE would show up to your workplace. You do have the right to ask if they have a warrant. If ICE does not have a warrant, you are allowed to ask them to leave your property. They operate the same way as other law enforcement, right? They can't just come into your place of business, look through all your records, seize any individuals from the workplace without a search warrant. So they need a warrant. If they can't produce one, you can ask them to leave and come back when they do get one. If they have a warrant, generally, you're going to need to let them in. You're going to need to let them in to the facilities that are covered by the warrant. So if you have a multi-facility workplace and a warrant is for a specific address, that warrant will allow them to enter that specific address, but not the address of other facilities. So, know the parameters of the warrant. While ICE is performing its job, you are allowed to observe. You cannot interfere. You can't step in. You can't, open the back door and tell everyone to run out. That would potentially expose you to some liability or risks of your own if you would engage in that type of behavior. And I think it's also a good idea for clients to make sure that their management teams, once you formulate this plan, are aware of what the plan is. How are we going to address this issue if it happens here? We obviously don't want to raise the alarm too much. We don't want to create a situation where we have a paranoid workforce thinking that this is going to happen, but we want our management level employees to understand that if this does happen, there is a plan in place. Here's how we're going to handle this. All right, so One Big Beautiful Bill also has a couple of other, I'm sorry, not One Big Beautiful Bill, Trump 2.0. There's a couple of other work-related impacts that we have seen so far and that we expect to see going forward under Donald Trump's second administration. The first is with respect to artificial intelligence. When we were together last year, Greg and I talked to you all about this artificial intelligence emerging technology and how it's impacting the workplace. With the Trump administration, so far, they have been extremely pro AI. The administration has said that it is its goal to ensure that the United States is the global leader in developing artificial intelligence technology. And that was a bit of a shift from the Biden administration. Under the Biden administration, the policy toward AI was, we want to be careful with this. We want to make sure that, while we want AI to develop, we want to make sure that there are protections geared toward workers, geared toward general consumers. And what we've heard so far from the Trump administration with respect to AI is the priority is, let's develop the technology. So there's not so much, at least we don't expect there to be so much of a regulatory focus on consumer protection, worker protection. We think AI is going to likely expand much more rapidly under the Trump administration than it would have had the Biden administration continued or had Kamala Harris won the election last year, because again, I think the Trump administration's goal, at least what it's stated so far, is we want to stay out of the way and let this develop as much as possible. So what does that mean for us as employers? Again, I think we're going to continue to see that expansion of AI. There's likely to be more products and programs becoming available at a much more rapid pace. And again, as employers, it's incumbent on us to make sure that we have appropriate policies, appropriate data privacy and security protections around our use of AI as that technology continues to become more and more available to us and become more and more ubiquitous over the course of the next 4 years. Another development under the Trump administration that has a direct workplace impact is the National Labor Relations Board. So most private sector employers in the United States are covered by the National Labor Relations Act. And of course, the National Labor Relations Act is overseen and administered by the National Labor Relations Board. One of the very first things that Donald Trump did upon his inauguration was to remove a couple of labor-friendly officials from the National Labor Relations Board. He terminated the National Labor Relations Board General Counsel. General Counsel's role at the board is to generally set the tone for the board's labor policy. And the prior National Labor Relations Board General Counsel was extremely pro-union. Under the Biden administration, we saw kind of the pendulum swing back from the first Trump administration, which was very employer-friendly as far as the National Labor Relations Board went, to a much more pro-union, pro-labor stance on various labor issues. That general counsel has been removed, which signals very much that the Trump 2.0 National Labor Relations Board, we expect to be much more employer-friendly. Why do I say we expect it to be much more employer-friendly? Well, the other thing Donald Trump did when he was inaugurated was he removed one of the board members from the board, which was sort of an unprecedented thing. We had not seen that before in the history of the National Labor Relations Board, where a sitting board member was terminated by a president. That termination was challenged in court. That board member remains terminated. And so the National Labor Relations Board right now, there are 5 seats on the board. There is currently 1 member on the National Labor Relations Board, 1 sitting member. So what does that mean and why does that matter for us as employers? Well, what that means and why that matters for us as employers is that the National Labor Relations Board currently with 1 member can't do anything. The board does not have a quorum. The board requires a quorum. And this is, by the way, not the first time the board has lacked a quorum. From 2000, I believe it was 2007 to 2013. So under most of President Obama's administration, the board lacked a quorum. And so that means that the board cannot set new case law precedent. It cannot overturn old case precedent while it lacks a quorum. So just yesterday, it looks like one of the president's nominees for the board is going to be moving forward toward a confirmation vote. So we are inching closer and closer to having that quorum restored. Once it is restored, which we expect it will be, most likely within the next 6 to 9 months. Once that board quorum is reestablished, I think what we will see is the pendulum swinging back again from sort of the pro-labor precedent set by the Obama board back to a more employer-friendly precedent by the Trump 2.0 board. So with that, we will move over to Greg, who's going to talk to us a little bit about some of the updates we've seen in the area of DEI in 2025.
Thank you very much, Micah. Good morning, everybody. So DEI is kind of the area that everybody's talking about with these new Trump updates, right? This is kind of the current area of uncertainty. If you remember, if you were here for Micah and I's presentation last year on AI, we said over and over again, that this is kind of a developing area and there's no clear answer. We can make predictions based on what's happened in the past, based on what we think is going to happen in the future. But because it's such a new area, it's hard to make a prediction. And DEI is kind of like that right now. And this is a new developing area that is a little bit uncertain and very different than what we've seen in the past. So Trump 2.0, one of the biggest things we got was 2 pieces of EEOC guidance. One was called What You Should Know About DEI-Related Discrimination at Work, and What to Do If You Experience Discrimination Related to DEI at Work. So it's based on these titles alone. Federal government is making a very clear stance on what they think about DEI programs in the workplace and the potential for discrimination lawsuits that can come out of them. They're almost encouraging this stuff, right? They're encouraging employees working at places that have DEI programs to say, oh my gosh, I have a DEI program at my office. Am I being discriminated against? So it's a very clear shift from the years and years that we've had in the past where DEI programs were commonplace. These 2 pieces of guidance raise several questions, and these questions come directly out of those 2 pieces of guidance. First is, what can DEI-related discrimination look like, and what is illegal DEI? We're going to get into the specifics of what those definitions might look like. The bigger question, number 2, is who can be affected by DEI-related discrimination? And this is where the crux of the shift happens. The answer to this question, in what we've seen so far from EEOC guidance, is that majorities are the ones who are likely going to be affected by DEI-related discrimination, as it's been termed by the EEOC. In the past, as all of you know, if you're in HR or any employment place, most of the focus on discrimination lawsuits and discrimination in the workplace focuses on minorities. I was discriminated against based on my protected class as a minority, race, religion, gender, sexual orientation, any of those protected classes. We're shifting a little bit. And the new focus from the federal government is, are these programs that were originally designed to promote inclusion for those minorities, are they discriminating against the majorities? And that's what some of this new guidance is suggesting. So some more direct questions that came out of this. Can an employer excuse its DEI-related considerations of race, sex, or another protected characteristic so long as it wasn't the sole or deciding factor for the employment action? The answer, as I'm sure you can guess, is no. Any sort of DEI-related consideration based on any protected class, whether it's a minority or a majority, any decision that an employer makes based on those protected characteristics is going to put the employer in danger. There's huge risks coming out of that. Second question is client or customer preference a defense for DEI-related discrimination? So if you have a client that prefers a female employee to do something, or an employee of color, or a homosexual employee, does that excuse providing work to the minority employee over the majority employee? The answer is no. That answer may have been a little bit different, but what you'll see as we go through some of these examples is that thought process that we used to use in determining, are we discriminating against these minorities based on protected characteristics, is now also going to need to be applied to the majorities. It is kind of equal across the board in how we're going to look at this. If there is any decision made based on any of those protected characteristics, whether that protected characteristic is the minority or the majority, if a decision is made based on that, there is a huge amount of risk for that. We can go to the next slide, Micah. So the case that really shook the foundation from the legal standpoint of what we've been so used to was Ames versus Ohio. So this was a 2025 case. This is very recent. It came out this year. And the facts of this case were there was a female employee whose superior was also female, but she was a homosexual female employee. The plaintiff in the case applied for a promotion. The plaintiff did not get the promotion. Instead, a subordinate of the plaintiff, who was also a homosexual female, was granted the promotion. So the plaintiff claimed what we used to refer to as reverse discrimination, and essentially said, hey, you, my boss, as a homosexual female, showed preference towards another homosexual female and gave her this promotion over me solely based on my sexual orientation. Now, we've seen a ton of sexual orientation discrimination cases in the past, but usually those plaintiffs were homosexual or any of the other various sexual orientation protected characteristics. They were not just straight. That's not what we're used to seeing in this type of litigation. Prior to this Ames case, if you were the majority in a protected characteristic, so in this example, if you were a straight female and you were making a claim for discrimination based on the protected characteristic of which you were in the majority, you had an increased burden. You had to show that the situation, the employer that you were working for, was in a special industry. There was a special circumstance that made your employer particularly at risk for discriminating against the majority. So we all know the burden for the prior burden for minorities having to show discrimination. It was just any decision made in whole or in part based upon a protected characteristic. That was not the same for majorities before the Ames case. What the Ames case did is it got rid of that enhanced burden altogether. Now that burden is the same regardless of whether you are in the majority or whether you're in the minority. If you are a Caucasian employee and you are claiming that you were not given a promotion based on your race and it was given to a minority employee, you now have a lesser burden to meet. So what does this mean? Obviously, there's a huge risk now that's shifting to majority employees. Cases that we maybe weren't used to evaluating as high risk, now we're going to share the same risk as any minority employee. So any decision at all made on the basis of any protected characteristic in whole or in part is going to bring enormous risk with it, the same as if you were discriminating against a minority. We can go to the next slide, Micah. So we also saw an executive order come out of Trump 2.0. And in keeping with the catchiness of the One Beautiful Bill title, this is called Executive Order 1473, Ending Illegal Discrimination and Restoring Merit-Based Opportunity. I'm not particularly creative, but I don't think that is a cool acronym. Nope, it's not. That's a bummer. So this executive order targeted the elimination of DEI programs for federal contractors and private entities. So before this happened, if you were a federal contractor, you had to take certain affirmative action steps to avoid discrimination in the workplace. So it wasn't just, oh, I'm not going to discriminate against my employees as a federal contractor. It was, I need to do these specific actions. I need to have this quota. I need to take these steps to ensure that I'm not going to discriminate against my employees in the workplace. And that involved tracking and data, that involves statistics, keeping track of how many minorities versus majorities that you had. It was all kind of all this extra stuff. If you're a federal contractor, I'm sure you're very familiar with it. It was a regular thing you had to do. Now, and we can jump to the next slide. Now that is almost gone. And I say almost because there are two protected characteristics that federal contractors are still required to maintain this data and take this step on. So this stops the affirmative action plans for decisions based on race and sex. So the typical ones that we were used to seeing. However, what stays and what we expect to stay is things that came from the Vietnam Era Veterans Readjustment Assistance Act, or VERA, which related to disability and veteran status. So federal contractors still have to take affirmative action steps regarding disability and veteran status. However, their race and sex affirmative action steps are no more, and they are actually explicitly not allowed to take those steps anymore. So under this new executive order, federal contractors have to agree that they comply with the applicable federal anti-discrimination laws, which, as we know, look a little bit different now than they did in past years based on their interpretation. And two, they're actually required to certify that they do not operate any programs promoting DEI if they're going to enter into government contracts. So federal contractors, and keep in mind, right now we're not talking about the private sector. We're not talking about private businesses. This is just federal contractors. They have to certify to the federal government that they do not operate a DEI program if they're going to be allowed to enter into government contracts. We can jump to the next one. Thank you, sir. I don't know who gave Micah control over this. That's a lot of power for him to wield.
I'm power tripping over here.
So I said this applies to federal contractors. This does not apply to private businesses, but it will have some impact on the private sector, if not to kind of give us a little glimpse of what the federal government wants to see come out of the private sector in the future. So federal contractors, like we said, are required to certify, hey, I don't operate any DEI programs whatsoever. I promise, please give me your government money as a contractor. I'm not going to operate DEI. What that suggests is that the private sector is also being encouraged to end DEI. Now, it doesn't specifically mandate that. There is no federal mandate that says, hey, you private employer need to end your DEI program. That's not to say that there's not risk with continuing to operate a DEI program. As we talked about before, if you do that, there is a large risk of a discrimination claim coming out. And that can look different, right? So if you have a group that is for, you have a special group for female executives, promoting, female executives in the workplace. Could a male that is not afforded the same opportunities as that group of female future executives, could they bring a discrimination claim? The answer is yes. And they have a lesser burden now than they did in the past to show discrimination. The same can be said with any sort of focus groups, and I use that example because they're very common for executives of color. These specific groups that employers may put together to help promote minorities and get them up the ladder. Those are a huge risk right now, given the state of the federal government. This executive order also outlined a plan for federal agencies to eliminate certain DEI programs in the private sector. And it also directed the Attorney General to create and submit a report on private sector DEI programs within 120 days. So this shows that they are paying attention to private sector DEI programs. They have made it much easier for a majority to file a discrimination claim, greatly enhancing the risk for private sector employers. And it also shows that they're watching private sector employers. They're seeing if DEI programs are continuing, and they're going to be aware of it. So this is an enormous shift from what we're used to, and there is a huge amount of risk right now for operating DEI programs in the workplace. So all that to say, what do we want to avoid? You can go to the next slide, Micah. So right now, our best advice is you want to treat any protected characteristic, regardless of if it's in the majority or the minority, the exact same. We want to avoid granting preferential treatment based on that protected characteristic. It does not matter if it is African American versus Caucasian. It does not matter if it is homosexual versus heterosexual. We do not want to grant preferential treatment to anyone based on those protected characteristics, nor do we want to make any sort of employment decision based on those characteristics. And most of these should be common sense. We don't want to segregate employees based off of their protected characteristics. But as we talked about before, sometimes that can happen in a workplace, and it may have been commonplace in the past, and we don't realize it, like special groups to promote opportunities for African American employees or homosexual employees or any other protected characteristic. If we are taking one protected group and putting them kind of by themselves and saying, here, you have more opportunities, that is discriminating against the other end of that protected group, even if the other end is the majority. Training programs that promote discrimination or hostile environments. So I am sure that no one in this room is developing a training program that is specifically telling your employees, hey, we're going to create a hostile environment based on protected characteristics. But what may be considered a hostile environment now is different than it was before the Ames case and before these executive orders. Now, programs that specifically promote one protected characteristic over another, even if it's just to, in intention, promote inclusion and diversity, if that results in any sort of opportunity, any sort of privilege that another part of that protected characteristic does not have, the argument is there, and there's a huge risk that that program can be considered a hostile environment that promotes discrimination. So the landscape looks very different right now, and what we would encourage is that same thought process that you use to avoid discrimination, that needs to be applied equally amongst every end of those protected characteristics, because it became much, much easier and the risk became much greater for a discrimination claim or agency action coming out of any of those programs.
All right, Greg, thanks for all of that cheerful information. I'm sure everyone's feeling great and wonderful so far. So let's keep that trend going. It's not just the federal government that is making some moves in the employment law space. We also have some state law developments to keep an eye on. All of these over the next two slides that we're going to talk about are currently bills pending before the Pennsylvania General Assembly. And they're ones that we wanted to call to your attention because they will have a significant impact on your workplace, depending on what, if they are passed. So the first one we want to talk about is House Bill 183. House Bill 183 seeks to expand certain workers' compensation benefits. So as everyone here knows, we have to carry workers' compensation insurance coverage if we have employees. And so the Workers' Compensation Act has historically provided benefits for scarring and disfigurement, in addition to your wage loss benefits due to a work injury, or your medical benefits that you're required, for medical bills that are incurred as a result of an injury. If historically under the Workers' Compensation Act, an employee sustains a work-related injury that results in scarring or disfigurement to the head, neck, or face, they're currently eligible to receive up to a maximum of 275 weeks of additional workers' compensation benefits to compensate them for that scarring and disfigurement. So, if you have an employee who's using a tool and the tool explodes and throws off parts and it cuts the employee's face and leaves scars on the employee's face, the employee could receive additional benefits over and above the benefits they would receive for any time missed or medical bills incurred as a result of that injury. HB 183 seeks to expand those scarring and disfigurement benefits in two really impactful ways if this legislation would get through. Number one, it would expand the eligible body parts for scarring and disfigurement benefits. As I mentioned, currently, scarring and disfigurement benefits are only available for head, neck, and face scarring and disfigurement. This bill would seek to allow those benefits to be compensable for any body part. And you think about that, right? Where we have a lot of work injuries that are orthopedic in nature. Someone has a shoulder injury, a knee injury, a low back injury. And a lot of times we'll see those orthopedic injuries require surgery. You have a surgical scar because you needed a knee repair, or you needed a discectomy in your lumbar spine. And those surgical scars, if this bill passes, could potentially open employers up to liability for paying for scarring and disfigurement in areas other than the head, neck, or face. So this could be a significant expansion in the eligible body parts, creating a lot more liability for employers and their workers' compensation insurance carriers. The next expansion, the other important expansion that HB 183 proposes, is to increase the maximum scarring and disfigurement benefit from 275 weeks up to 400 weeks. So when we talk about weeks, in workers' compensation, we mean weeks of temporary total disability benefits, which are roughly calculated at about 2/3 of an employee's average weekly wage at the time they were hurt. So 2/3 of their average weekly wage at the time they were hurt is their weekly benefit, total disability benefit amount, roughly. We're talking about possibly expanding those maximum scarring and disfigurement benefits all the way up to 400 weeks, adding another 125 weeks of benefits to be potentially eligible for compensation for scarring and disfigurement. So what does that mean? Well, it means a couple of things. One, particularly egregious scars or disfigurement will be bumping up against that 400-week cap. So now we're looking at a potential little over 2 years of temporary total disability benefit compensation for particularly egregious scars. The other thing that I think would happen if this bill passes is that lesser scars, ones that probably don't go all the way up to the maximum, they're probably going to carry a higher value now too, right? Because we don't have all that compression between 0 weeks and 275 weeks. We've got a much broader spread. Workers' comp judges are going to have a much broader menu to choose from as far as how they evaluate scars. And I think that would dramatically increase the value of any scarring claim, not just those most egregious disfiguring scars that might be bumping up against the cap. So what does this mean practically for us as employers? Well, it means that if this bill passes, we're probably going to see some pretty dramatic increases in costs of insurance, workers' compensation insurance. Obviously, carriers are for-profit businesses, and they're very profitable businesses. They are not going to absorb these additional costs. They're going to pass them along to you as their customers in the form of increased premiums. So this is one to absolutely keep an eye on and follow as it works its way through the legislature. I believe it did pass the House, and this one is currently sitting before the Pennsylvania Senate. It's another bill currently pending before the House of Representatives, and that is the Workplace Safety and Extreme Heat Bill. And what this bill does is it seeks to limit employee exposure and health risk in, quote, extreme heat. And so what that means is that this bill seeks to require certain protections be made for employees when they are working in a hot environment. That would be to allow them to have breaks as needed. There has to be water made available to them. And it also provides additional protections to them should this bill be passed. Those protections include employers would be prohibited from disciplining or terminating an employee for leaving work to seek medical treatment related to heat exhaustion or a heat-related medical event. It would prohibit employers from disciplining or discharging employees for complaining or reporting concerns about heat in the workplace. And so, another bill that we need to keep our eyes on as employers, because that's going to dramatically change, potentially, again, if it's passed, it would dramatically change the way things currently are, right? So you can have workers theoretically under this workplace safety in extreme heat bill refusing to continue to work. They're going to walk off the job. Hey, I have heat exhaustion. I don't feel like I can continue. And of course, that seems well-intentioned, but I think most folks that are on the call are also not naive, and we understand that there are going to be those employees who would seek to take advantage of a protection like this. It's hot. It's a tough job that I'm doing. I don't feel like doing it today. No, I don't feel like I'm about to have a medical emergency, but if I say I'm going to go see a doctor, or maybe I just run over to urgent care, I can get myself out of work for an hour. And if this bill passes, there's not much we can do as employers. So this bill is currently pending before the House of Representatives. It has not cleared the House yet, but one for us definitely to keep our eyes on as well as employers. We have another bill that was tabled. I said it was tabled this month. I meant last month. It was tabled in November. So fortunately, this one is not making it out of the House anytime soon, but something to be aware of. There is a push in the Pennsylvania legislature to establish state-mandated paid family leave. The bill that was tabled specifically provided that all Pennsylvania employers would be required to participate, and employers and employees through payroll deductions, contributions would be required to pay into a fund that would be administered by the Commonwealth. And an employee who needed medical leave under the paid family leave bill would apply to the state, and they would be eligible for up to 20 weeks of paid leave. So that would be a dramatic title shift in terms of leave entitlements and paid leave entitlements here in Pennsylvania. Pennsylvania law currently does not require us to offer any paid family leave of any kind. And, this bill, the first swipe at a paid family leave bill in Pennsylvania suggests 20 weeks. That's almost a half of a year of paid family leave that our legislature has proposed. So again, this bill is tabled. This one is not going to make it into law, at least anytime soon. But we want to put this on your radar to let you know this is happening. This is a legislative priority in Pennsylvania, and it's something to keep an eye on and to begin to consider and begin to think about now, because Pennsylvania, we're sort of on an island amongst our neighbors. New York, Virginia, Maryland, Delaware, they all have paid family. New Jersey have paid family leave statutes, and Pennsylvania looks like we're going to try and join that group and kind of follow the majority of our neighbor states sometime in the near future. So something to keep track of, keep in the back of your mind as we move forward. Finally, House Bill 721 seeks to amend the Construction Workplace Misclassification Act. So Construction Workplace Misclassification Act is focused on eliminating employers' ability to misclassify construction workers as independent contractors. HB 721 seeks to add a little more teeth to the Construction Workplace Misclassification Act for those misclassification decisions where we improperly classify a construction employee as an independent contractor when truly they should be an employee eligible for employee benefits, subject to minimum wage, overtime, etc. And specifically, HB 721 includes the following penalties. One, disbarment from public projects. So if this bill passes, you violate the Construction Workplace Misclassification Act. This bill would give the Commonwealth the ability to disbar that employer from performing any work on public contracts. That could obviously have a major, major negative impact for an employer who finds himself in that situation. In addition, there's also potential criminal penalties proposed in this for repeat or intentional offenders. So those employers that, repeatedly or intentionally are misclassifying workers as independent contractors to try and avoid minimum wage requirements, overtime requirements, employee benefit issues. Those employers who are acting intentionally, repeatedly, or willfully, they could be potentially subject to criminal charges. Again, this one pending before the House of Representatives currently, another one for our friends who are in the construction industry to keep an eye on. There was one law statewide that was recently passed that all of our attendees here today should be aware of. We should make sure we're ready to comply with next month. So starting in January 2026, there is a new workplace posting requirement. The Pennsylvania Department of Labor and Industry published the poster that's here on the slide for employers in Pennsylvania to post in the workplace along with the rest of your workplace postings. And this poster notifies veteran employees of various benefits and services that are available to them. I want to be clear, this does not require employers to create new benefits for veteran employees. This is just a posting requirement so that we are notifying our employees who are veterans of various services that are available to them through the state and federal government. The poster itself can be found on the Pennsylvania Department of Labor and Industry's website. You can obtain a copy, I believe, for free from the website, and you can post that copy in hard copy. If you've got a bulletin board where you've got your Fair Labor Standards Act poster and your workers' compensation poster and all that fun stuff, you can post it there. You can also post it digitally if you have an intranet that your employees can readily access. So with that, we have a couple of minutes left, I think, until 11 o'clock here, if anyone has any questions. I do see that we had one come through earlier in our presentation. Donna asked us, with respect to the overtime reporting, the report should show only the deductible amount, not the total paid. So for time and a half, only the half is reportable. Yes, the overtime premium is the portion that is eligible for the tax deduction. The overtime premium amount, the and a half, is what employees will need to know for their tax deduction purposes. If there are any other questions, please feel free to submit them. Otherwise, we're happy to give you back about 5 minutes to your day.